I'm a 34-year-old woman. I'm an occupational therapist at a mid-sized rehab hospital in the Midwest. I rent a decent apartment. I drive a 2019 Honda CR-V that's almost paid off. I have about $22,000 in a savings account that took me 6 years to build after paying off my student loans. I'm not rich, not poor, just steady. I've worked hard for steady. I genuinely love my job, I have good friends, and until 18 months ago, I thought I had a decent relationship with my family. My brother Marcus is 38. He lives in Nashville. He has what I would describe as an extremely optimistic self-image. He genuinely believes he is one good idea away from being wealthy, and he has believed this for 20 years. The good ideas have included a food truck folded in 4 months, a premium dog grooming subscription service, never launched, a real estate wholesaling operation. I still don't fully understand what happened there. A dropshipping business dissolved after a cease and desist from a brand he was counterfeiting, which I didn't know about until recently. And most recently his girlfriend Trish's wellness and lifestyle coaching brand, which from what I could tell mostly consisted of Trish posting motivational content on Instagram and selling $300 transformation journals. Our dad passed away 3 years ago. Our mom passed 14 months ago. I'm telling you this so you understand. I was not paying close enough attention when I should have been because I was grieving. That grief is something Marcus used like a tool. My parents weren't wealthy, but they were careful. My dad worked 40 years as a civil engineer. My mom worked part-time as a bookkeeper until she retired. They owned their house outright, a 4-bedroom in a suburb of Columbus, Ohio, paid off since 2011. They had a modest investment account, 2 smaller savings accounts, and a life insurance policy. When my dad died, everything passed to my mom per a simple will. When my mom got sick, she had a fast-moving lung cancer diagnosis. About 10 months from diagnosis to death, she updated her estate documents. Or so we were told. Here is what I knew at the time of my mom's death. Marcus was listed as executor of her estate. I was listed as co-beneficiary along with Marcus on all assets. The house was to be sold and the proceeds split equally. The investment account, estimated at roughly $180,000 at the time my mom got sick, was to be split equally. There was a $100,000 life insurance policy, split equally. So my understanding was, when everything settled, I would receive somewhere in the range of $190,000 to $220,000 depending on how the house sold and how the market treated the investments. That was my expectation. I didn't obsess over it. I was sad. I missed my mom. I wasn't waiting for the money, I was just aware it was coming. Marcus was the executor. He was local to Columbus. He'd actually moved back there from Nashville a few months before Mom died, which I thought was sweet at the time. I'm based in Michigan. I trusted him to handle things. He gave me updates. He told me the estate was complicated and would take time. He told me the house sold for $312,000, which felt low but not impossible for that market. He told me the investment account had taken some losses and was down to around $140,000. He handled the lawyer. He handled everything. The first check I received was for $71,000. Marcus told me this represented my share after estate taxes, attorney fees, the cost of selling the house, and settling some debts Mom had that we didn't know about. I didn't question it hard enough. I was grieving, I was exhausted. $71,000 felt like a real number. I cried, I thanked him, I put it in savings. That was 13 months ago. The first warning sign came from a completely random direction. My mom's former neighbor, a woman named Deb who had lived next door for 15 years, sent me a Facebook message in February. She said she'd heard I sold the house, and she just wanted to say she hoped the family was doing okay. She mentioned that she'd been surprised by the sale price. She said a comparable house on the street had just gone under contract for $378,000, and she thought it was wonderful that our family had gotten such a great price of $341,000. I remember reading that message 3 times. I'd been told the house sold for $312,000. I wrote back to Deb and asked her if she was sure of the number. She was. She said she remembered because she'd chatted with the buyers, a young couple, and they'd mentioned what they paid. $341,000, not $312,000, a $29,000 discrepancy. I told myself there could be an explanation. Maybe Deb misheard, maybe the buyers misspoke, Maybe there were closing costs I wasn't accounting for. But I couldn't let it go. I spent 2 evenings on the Franklin County Auditor's website, which has public property records. It took me a while to find it because Marcus had handled the sale and I didn't know the exact date, but I found it. The house sold for $347,500. Not $312,000, not $341,000, $300 and $47,500. That's a $35,500 difference from what Marcus told me. My share of $35,500 is $17,750. I sat with that number for a long time, then I started looking at other things. I don't have a legal or financial background, but I'm organized. I'm an OT, organization and systematic thinking are core to the job. I started making a list of every number Marcus had given me, then I started trying to verify each one. The investment account was the next thing I looked at. Marcus had told me it was worth about $180,000 when Mom got sick, had taken some losses, and came out to roughly $140,000 by the time it was distributed. He said after fees and taxes, my share was around $58,000, which he'd rolled into my $71,000 check. I called the investment firm directly. I still had the account number from paperwork my mom had shared with me years ago. The representative was helpful once I established I was a named beneficiary. She told me the account balance at the time of my mother's death was $193,400, not $140,000, and more importantly, the account had been liquidated in 2 transactions. The first transaction, about $90,000, had been processed 6 weeks before my mom died. 6 weeks before she died, my mom was in hospice. She was on significant pain medication. She was not making financial decisions. When I asked who had authorized the transaction, there was a long pause. The representative said she couldn't give me detailed authorization information over the phone and suggested I submit a formal records request. I requested the records. While I waited, I found myself going back over every conversation with Marcus from the past year. All the times he'd said things were complicated. The time he mentioned that Mom had some debts we didn't know about, which I'd accepted without ever asking for documentation. The way he'd always had a reason to delay, to say it wasn't the right time, to steer the conversation away from specifics. I thought about the fact that Trish's Instagram suddenly had posts about investing in their brand's expansion, right around the time the estate was being settled. I thought about the new truck Marcus was driving when I saw him at Christmas. I was starting to feel sick. The investment firm records arrived and confirmed what I'd feared. The $90,000 withdrawal 6 weeks before Mom's death had been authorized with a power of attorney document. Marcus had been granted POA over my mom's finances when she got sick, which was legitimate and something I'd known about. But the POA does not authorize using funds for personal benefit. It authorizes managing funds on the principal's behalf. He had transferred $90,000 from the investment account to a personal checking account, his personal checking account. I now had documentation showing house sale misrepresented by $35,500, investment account misrepresented by $53,400, the difference between actual balance and what he told me. $90,000 withdrawn before death under questionable circumstances. That's potentially over $178,000 in discrepancies, before I even knew what I didn't know. I called a probate attorney. She was the third attorney I spoke to. The first 2 were too busy, the second was in a different state. This one, I'll call her Patricia, was sharp and took the case on a contingency plus hourly hybrid once I showed her the documents I had. Patricia's first words after reviewing my initial file were, "This is not an accounting error." Her second words were, "Don't contact your brother yet." I didn't contact Marcus. I went back to work, kept my routines, kept paying my bills. I didn't post about it. I didn't tell my closest friends yet because I was afraid I'd say something that would get back to him through social media. I just waited and kept building the file. Patricia subpoenaed the estate records. That's when the next layer came off. The attorney Marcus had used to process the estate was not a probate specialist. He was a general practice attorney in Columbus who, it turned out, had done 2 other estate matters for people connected to Marcus. Patricia pulled his bar registration. He was active and licensed, but he had a prior disciplinary notation for inadequate communication with clients. Nothing criminal, but a flag. More importantly, the estate documents on file with the probate court showed something that made Patricia call me at 8 p.m. on a Tuesday. My signature was on a document I had never signed. It was an agreement to modify the distribution terms of the estate, specifically a waiver of my right to review a full accounting of estate assets before distribution. It was notarized. My signature, or what was supposed to be my signature, was dated 4 months after my mom's death. I was in Michigan 4 months after my mom's death. I never signed anything in Columbus. I never signed any waiver. I had never even heard of this document. Patricia said, "Someone forged your signature and had it notarized." I asked what that meant legally. She said, "Felony, several of them potentially." I need to pause here and tell you what happened when I finally confronted Marcus, because it did not go how I expected, and it changed everything I thought I understood about my family. I want to be clear. Patricia told me not to confront him yet. I made a mistake. I was sitting at my kitchen table at midnight looking at a PDF of my own forged signature, and I called him. He answered on the third ring, sounded half asleep. I told him I knew about the house. I told him I knew about the investment account. I told him about the forged signature. There was a long silence. Then Marcus said, and I am typing this word for word because I wrote it down immediately after we hung up. I was going to make it right. I needed it temporarily. You have a job, you have savings, you were fine. Mom would have wanted me to use that to build something real. You can't prove the signature wasn't something you forgot you signed. I said I absolutely never signed that document. He said, "Who's going to believe you over the executor? You want to drag Mom's name through probate court over money. That's who you are." Then he said, "Be grateful I didn't take more. I could have structured this so you got nothing." I hung up. I called Patricia the next morning and told her what he said. She was annoyed I'd called him but said it was actually useful. I'd recorded the call. Ohio is a one-party consent state. She listened to the recording and said, "Good, that's an admission." Now here is where the story gets genuinely strange, because this is when we found out Marcus hadn't just stolen from me. Patricia hired a forensic accountant, a woman I'll call Gwen, to go through the full estate. What Gwen found over the following 6 weeks restructured everything I thought I knew. The $90,000 that Marcus withdrew before Mom died, he'd used $68,000 of it to pay off the debt of Trish's business, which had apparently accumulated significant credit card balances and a defaulted small business loan. Gwen found wire transfer records. The money went directly into a business account in Trish's name. The remaining $22,000 had been used for, and I want you to appreciate the specificity of this, a down payment on a camper van that Marcus and Trish used for a brand content road trip in the fall. There are Instagram posts, with timestamps. But the bigger thing Gwen found, the thing that made my attorney go completely quiet for a moment before she spoke, was that the life insurance policy had been changed. My mother's $100,000 life insurance policy had named me and Marcus equally as beneficiaries for as long as I could remember. But 8 months before she died, while she was sick, while she was on medication, while Marcus had POA, the beneficiary on the policy was changed. To Marcus only. I had never received a penny of that life insurance policy. I hadn't known to ask about it specifically because I'd assumed it was handled and part of the final distribution. It was not. Marcus had collected $100,000 directly, outside of the estate, and never mentioned it to me. That's not a probate error. Beneficiary designations pass outside of the will. He didn't have to disclose it. But changing a beneficiary while you hold POA over an incapacitated person is a textbook example of financial elder abuse. When I learned this, I sat on my bathroom floor for about 20 minutes. By this point we had a file that included 1. Documented misrepresentation of house sale proceeds, difference. 2. Misrepresented investment account balance, $53,400. 3. Pre-death unauthorized transfer of $90,000 to personal account, then to Trish's business and a camper van. 4. Forged signature on estate waiver document. 5. Fraudulent notarization of that document. 6. Suspicious beneficiary change on life insurance policy while mom was incapacitated. 7. Undisclosed receipt of $100,000 life insurance payout. Patricia filed a complaint with the Columbus Police Department Financial Crimes Unit. She filed a complaint with the Ohio State Bar against the estate attorney. She filed a motion in probate court to reopen the estate. She also sent a formal demand letter to Marcus. He responded through his own attorney, a different one than the estate guy, saying that the withdrawals were authorized by our mother, that the beneficiary change was made at our mother's request, and that any signature discrepancies were clerical in nature. His attorney also sent a letter suggesting I was motivated by grief and jealousy, and was attempting to relitigate a settled estate for personal financial gain. I forwarded the letter to Patricia. She forwarded it to the forensic accountant. Gwen sent back a 17-page report. Here is what I didn't know about Gwen until this point. She had previously worked as a financial investigator for the Ohio Attorney General's office. When she started finding things, she found all of them. The estate attorney's notarization on the forged document. The notary stamp was registered to the attorney's paralegal who had since left the firm. Gwen tracked her down. The paralegal, when contacted by investigators, said she had been asked to notarize documents without witnessing the signatures, which she said she had been told was fine for estate paperwork. She cooperated fully. She had records. The investment account's $90,000 transfer. The authorization form on file at the investment firm showed Marcus's handwriting on the description field, but the signature block was signed differently than every other signature Marcus had on file. A handwriting analyst confirmed the account holder signature was not consistent with known samples of my mother's handwriting from that period. It was consistent with Marcus's handwriting. He had signed his dying mother's name to drain her investment account. And then it got worse in a different direction entirely. Gwen, while reviewing financial records, found that Marcus had also taken out a personal loan using the Columbus house as collateral, before it was even in the estate, while our mother was alive but incapacitated. He had borrowed $40,000 against the property. That loan was paid off from the sale proceeds, but it had never been disclosed as an estate debt. It was a personal loan Marcus had taken out. He'd borrowed against our mother's house while she was dying without her knowledge, and then paid it back quietly from the sale without telling me. So the $35,500 discrepancy in house proceeds was only part of the story. There was also $40,000 in undisclosed loan proceeds he'd already spent. I did the math with Gwen and Patricia in a conference call that lasted almost 2 hours. Total assets from my parents' estate, approximately $640,000, house $347,500, investment account $193,400, life insurance $100,000, plus one smaller savings account that had been drained. We found evidence of this later, adding another. My documented share, 50% equals approximately $320,000. What I actually received, $71,000. Estimated misappropriated from my share alone, approximately $249,000. Marcus knew we were building a case because of the demand letter, but I don't think he understood how deep it had gone. His response to the probate motion was dismissive. His attorney filed a brief calling the forensic accounting speculative and motivated by sibling rivalry. Marcus, in a group text to extended family members, wrote a message saying I had been manipulated by a predatory attorney and that I was trying to destroy our mother's legacy over money. Several relatives took his side publicly. One aunt posted on Facebook that I was tearing the family apart. A cousin called me and told me I should drop it for everyone's sake. Marcus told people I had always been jealous of him. My phone was, as the Reddit saying goes, absolutely blowing up. I said nothing publicly. Patricia had advised me to stay silent. I stayed silent and let people think what they thought. Meanwhile, Patricia had been in contact with the Franklin County Prosecutor's Office. The financial crimes detective had reviewed our file. The forged signature and fraudulent notarization alone were sufficient for charges. The beneficiary change while holding POA was being reviewed by the state's Elder Financial Abuse Unit. The investment account transfer with the forged signature was being reviewed as a second forgery charge. Patricia also, and this one I hadn't expected, contacted the IRS. because Marcus had received $100,000 in life insurance that he had not claimed as a beneficiary change under appropriate circumstances, and because there were questions about whether the estate had been properly reported for federal estate purposes, and because $90,000 had passed through the estate without proper accounting, the IRS had questions. Marcus, it turned out, had not filed federal taxes for 2 of the past 3 years. The charges came on a Thursday. I got a call from Patricia at 9:47 a.m. She said, "He was arrested this morning." Marcus was charged with estate fraud, forgery 2 counts, fraudulent notarization, as a co-conspirator, financial exploitation of a vulnerable adult, for the investment account transfer and insurance beneficiary change, and theft by deception. The estate attorney was referred to the Ohio State Bar and additionally charged as a co-conspirator in the forgery. He had signed off on documents he knew or should have known were fraudulent. His license was suspended pending investigation. The paralegal was granted immunity in exchange for cooperation. Trish, this is the part I almost didn't believe, was named in a civil complaint filed by Patricia on my behalf because $68,000 of stolen funds had been transferred directly into her business account. Whether she knew the origin of the money is a question for her own attorney. She hired one fast. Edit, a lot of people are asking about the recording. Yes, I had it. Ohio is one-party consent, so it was admissible. His attorney tried to challenge it anyway and failed. Also, yes, I know I should not have called him before Patricia told me to. I know. It worked out, but it was genuinely stupid and I got lucky. To the people in my DMs asking about the relatives who took his side, I have not reached out to any of them and I don't plan to. When the charges became public record, which happened fast, local news picked it up, several of them went quiet. One aunt sent me a text saying she didn't know the full story. I didn't respond. I'm not interested in managing their feelings right now. To the person who asked if I still love my brother, that's a complicated question I'm not ready to answer on Reddit. Update 1, posted approximately 6 weeks after original post. The probate court has reopened the estate. This is the legal mechanism that allows the court to reassess and correct the distribution. What this means practically is that the fraudulent waiver I supposedly signed is void, and the estate must be re-administered correctly. The estate attorney's malpractice insurance has already made a preliminary settlement offer to avoid civil liability. I can't discuss the amount publicly because there's a confidentiality clause in the offer, but Patricia says it's reasonable as a starting point, and we're still negotiating. The criminal case is moving slowly because they always do. Marcus was released on bail, $75,000, which his mother-in-law, Trish's mom, apparently paid. He is not allowed to leave Ohio without court permission. His Nashville life is on hold. I got a call from one of Marcus's old friends, a guy I've known since childhood, who told me that Marcus is devastated and that he really believed he deserved it because of everything he'd done for the family. This friend wanted me to consider not pressing charges. I told him that I hadn't pressed charges, the state had, and that there was nothing I could do to stop a criminal prosecution even if I wanted to, which I don't. The IRS situation is separate from everything else and apparently ongoing. That's all I know about it. One more thing from this update, the smaller savings account I mentioned, the one that had been drained. Gwen traced it. The account had about $22,000 in it when our mother died. That $22,000 was withdrawn in cash in 4 transactions over 3 weeks. ATM records show the withdrawals were made in Nashville, Marcus's hometown at the time. He was visiting to help with arrangements during that period. Cash just gone. My mother built that money over 40 years. Update 2, posted approximately 3 months after original post. A lot has happened. The estate malpractice settlement finalized. I'm not allowed to give the number, but it was significant enough to meaningfully help me while the bigger legal processes move forward. Patricia says the estate attorney knew what was happening and actively participated by filing fraudulent documents with the court. His license has been formally suspended and the disciplinary board is pursuing disbarment. More importantly, the probate court issued its corrected accounting. Based on Gwen's forensic report, the judge found that my share of the estate had been substantially misappropriated and issued an order for Marcus to repay the estate. That order is essentially a civil judgment that attaches to any assets he has. He doesn't have many assets, the truck is leased. The camper van was in Trish's name, which is now a problem for Trish's civil case. The Nashville apartment he shared with Trish they were renting. What Marcus did have, apparently, was a business account with some money left in it from a PPP loan he had received during COVID. Yes, that Marcus. Yes, that's exactly what you're thinking. Gwen found it during the financial investigation and referred it to the SBA Inspector General. I'm not going to say more about that because it's separate and still under investigation, but I want you to understand that every layer we pulled back revealed another layer underneath. The criminal preliminary hearing happened 2 weeks ago. I did not attend. Patricia represented my interests as the victim. Marcus's attorney tried to argue that the POA document gave him broad authority over the estate and that my mother had verbally authorized all transfers. The judge did not appear moved by this argument. The case is proceeding to trial. Trish settled the civil case. I cannot discuss terms. She and Marcus are apparently still together, which tells you something about one or both of them. The relatives who had been publicly defending Marcus have almost entirely gone silent. The Facebook post from my aunt got quietly deleted. Nobody has apologized to me directly. I have accepted that this is how it will be. Final update, posted approximately 8 months after original post. I've been putting off writing this because I didn't want to write it until I actually had something to say. Now I do. Marcus took a plea deal. He pled guilty to estate fraud, 2 counts of forgery, and financial exploitation of a vulnerable adult. The theft by deception charge was dropped as part of the plea negotiation. He was sentenced to 28 months in a state correctional facility, with the possibility of early release at 18 months for good behavior, followed by 5 years of supervised probation. He is also required to pay restitution. The court-ordered amount is $247,000, which is calculated based on Gwen's forensic accounting and the corrected estate distribution. He will almost certainly never pay that restitution in full. I know this. Patricia told me going in not to expect the money to materialize, but the judgment exists. It follows him. If he ever has assets, a property, an inheritance, a settlement, it can be collected. For the rest of his life, that $247,000 hangs over him. The IRS matter resolved separately. Marcus owed back taxes, penalties, and interest. He is on a payment plan. Combined with the restitution, he will be financially underwater for the foreseeable future. The PPP loan referral to the SBA Inspector General, still under investigation. That's all I know. His attorney will have to deal with it. Here is what I actually received once everything was tallied. The estate malpractice settlement covered a substantial portion of attorney fees and gave me the first meaningful recovery. The corrected estate distribution, ordered by the probate court, resulted in an additional payment that I am still waiting to fully receive. It requires liquidating some of Marcus's remaining assets through the court, which takes time. Based on the current projections, I expect to recover somewhere between $160,000 and $185,000 of what was taken, not counting what I already received. Combined with the $71,000 I originally received, that puts my total recovery somewhere around $231,000 to $256,000 out of approximately $320,000 that should have been mine. Not everything, but a real amount, enough to matter. Here is what I did with the first recovery payment. I bought a house. A small one, 2 bedrooms, a yard, needs some work. It's in the same city where I've built my life, near my hospital, near my friends. I closed on it 3 weeks ago. I cried in the parking lot of the title company after signing. My parents bought their house in 1987. My dad paid off the mortgage in 2011. My mom kept it clean and planted flowers every spring. Marcus sold it and used the money to fund a lifestyle Instagram account and pay off credit cards. I own a house now, my own, with my name on the deed, just mine. I'm not going to pretend the money makes everything okay, or that I don't grieve the fact that my relationship with my brother is finished, that I don't sometimes sit with the specific sadness of what he chose to be when the moment came. I'm not going to pretend I'm not angry at myself for not looking more carefully, not asking harder questions, not verifying before I trusted. But I also know this, I caught it. I made the call to Deb and I let myself be bothered by a $29,000 number that felt wrong. I kept the records. I found Patricia. I trusted Gwen. I stayed quiet when every instinct wanted to fight loudly, and I rebuilt. Marcus is in prison. The attorney who helped him lost his license. The money he stole is a judgment that follows him for life, and I have a house with a yard where I am going to plant flowers in the spring. My mom would have liked that, I think,